Hey guys, I'm Sahil Bansal. In this series, we're doing a deep dive into the Code of Civil Procedure 1908 with a focus on clarity, structure, and a close reading of the text of the legislation and the case laws. In the last session, we began by recapping the session before that. We discussed sections 121 to 131 of CPC, which fall under part 10 of CPC. In the main body, which is containing the parts and sections, this part was titled as Rules. In sections 121 to 131, we discussed the sections, the provisions governing the rules, the orders, that is basically the first schedule of CPC. We discussed who can amend it. We discussed how both judiciary and the state, the legislature, plays a role in it. We discussed the importance of sections and the rules is equal. We discussed an apparent hierarchy that is present wherein the rules are required to be in compliance with the sections. We also discussed the ambit of the powers of the High Court in amending these rules is a very general power that's given, and then we saw how some examples have also been given under the law as to what all kinds of civil procedures in a civil suit, in a trial, can be dealt with by the rules, which is basically all of them. And we saw some examples have been given in the CPC, but it is clearly mentioned that this mention of a few examples is not at all to prejudice the generality of the powers that have been given. Then we also saw some principles that were ingrained in these provisions. We saw the importance of publication, which tells you that it is important that people know the law, because the rule is that later on, once you are told what the law is, you cannot plead that I was ignorant as to what the law was. With respect to that, I would like for you to take down a Latin maxim, which is ignorantia lex non excusat, comma, ignorantia facti doth excusat, which translates in English to ignorance of law is not excusable, ignorance of fact is excusable. Ignorantia is spelled as ignorantia, lex lex, non non, excusat, excusat. And the second part of this maxim, facti, is spelled as facti doth. So this is the maxim from which we derive this rule that ignorance of law is not an excuse. But this maxim is only applicable if people in the first place were made aware of the law in some manner or the other. And this manner in the country is publication. So publication is very important. Hence you see two different sections in one part, part 10 itself, dealing with publication of the amendments that are being made to the law. After discussing sections 121 to 131, before I proceed, I flagged that you should look up 5 high courts in the country, which are the only 5 high courts with original jurisdiction. I briefly told you what is original jurisdiction. If you looked up, amazing. But if you didn't, they are basically Calcutta High Court, Bombay High Court, Madras High Court, Delhi High Court, and your Himachal Pradesh High Court. So there are 5 high courts: Bombay, Calcutta, Madras, Delhi, and Himachal Pradesh. These are the 5 high courts which have original jurisdiction. And so now you know it. So basically, if you look at a case, a suit, a plaint which is filed in the original side. So original side of a high court means the side which deals with the cases coming to the high court in its original jurisdiction. You will see that there the case number that you have, you will usually see it is CS. But for for an original side suit, you will see, for an original side suit, you will see it mentions CS, and in the bracket it says O. That means it has been filed in the original side. A small thing for you to look out for whenever you look at a document, you will be able to see it. Then after discussing part 10, after discussing the different principles, after discussing the things related to first schedule and the main body of the legislation, we further moved on to discuss the principle of procedure is the handmaid of justice and not its mistress. We discussed it at length. We discussed why justice is important. We discussed why is procedure important and how procedure can never topple justice. Justice can always ask procedure to rework itself in order to achieve justice, but it cannot be the other way around. After discussing this, we got into the very first discussion of how a civil suit proceeds. We discussed where it begins, what sparks a civil suit, where does one get the right to file a civil suit, when does this right arise, what has to happen for this right to arise, and how we file it and how it proceeds. Let's begin discussing about what we did. So we divided it into 11 steps, wherein one of the steps was 7 and 7A. So that way it's 12, but we have 11 numbered steps that we put down yesterday. Let's discuss it once again, and this time we'll add some more details to this whole discussion. So the first step in filing of a civil suit was for a cause of action to be there. If you don't have a cause of action as a plaintiff, you're not allowed to file a civil suit. That is why whenever you will even file a plaint, that plaint will have to explicitly mention that you have a cause of action to file this suit. Because otherwise the very first question that will be put to you is that why are you here? What right do you have to file this suit? We will read and discuss when we discuss plaints that your plaint will be rejected outrightly if it is not mentioning the cause of action explicitly. Cause of action has to be mentioned in a plaint. So you first have a cause of action that arises, which arises when you have a civil right and that right has been breached. So once that right has been breached, you have a civil action which you can take, and that becomes your cause for such civil action, and then you will draft a plaint. Now, when you have a plaint, this plaint is going to contain your pleadings, which is basically your side of the story. Now, there are some fixed elements in a plaint that will always be there. There will always be a mention of the cause of action. If you don't mention your cause of action in the plaint, your plaint will actually be outrightly rejected. It will not be heard upon. Because cause of action is the very basic element that gives you the right to file that civil suit. So you have to very outrightly tell the court in your plaint as to why are you here in this court with this plaint. What gives you the right to come here? So when you write your cause of action, you will mention the right that you had and how it was violated. And that is why you have the right to file this civil suit now. If you don't mention your cause of action, your plaint will be outrightly rejected. It has been provided in Order 7, Rule 11. We'll discuss it, but you can take it down and keep a note of it somewhere if you want. Then you will have your technical pleadings. Your technical pleadings are basically declarations of sort that my plaint is not to be rejected, not to be rejected on any of the technical grounds because all of this have been met. For example, you will declare that the court where you're filing your plaint has a jurisdiction to try this case. Because if the court does not have the jurisdiction to try this case, your plaint will not be heard there. Your case cannot be tried there. Because that court does not have the power to try that case, to try that suit. Hence, you will mention it in your technical pleadings itself. Then you will have your pleadings on merits. This is where you will put down all your facts. This is where you will talk about matters in issue. Matters in issue is a technical term. It means simply whatever it means in simple English language. That you will mention the matters, the facts which are in the issue. Then there you will mention what all you're pleading to the court. Then you will come to reliefs after your merit-based pleadings are done. In the reliefs, you will mention exactly what relief or remedy you are claiming from the court. That will be mentioned. Once you have drafted your plaint, then you will come to the court, to the filing counter. Every court has a filing counter. This filing counter can have different names. It may be called filing counter in some courts. It may also be called a facilitation center in some courts. It may also be called a Suvidha Kendra. So when you come to a court, you will give your plaint to the Suvidha Kendra and facilitation center. Now, will this plaint just be a piece of paper? Will you just write on it and then give it? No. There will be a number of things that will go with the plaint. First of all, you will have to put certain number of copies of that plaint, original copies. Original copies of that plaint have to be there. We'll see provisions in CPC which require that. So a plaint has to go with its original copies. There will be at least 2 original copies of that plaint that will go in. Then you will also attach your documents. If you're writing your plaint, you will mention some documents using which you're proving your pleadings. So those documents, whenever you mention them in your plaint, you will mention next to them that this document is attached with this plaint as Exhibit 1, Exhibit 2, Exhibit 3. All these documents you will have to attach with your plaint, and you will also have to make an index for these documents, and you will have to attach, that is called the list of documents which has to be attached with your plaint. So your plaint will contain the parts of the plaint itself. It will contain the documents that have been attached with that plaint. It will have to be filed with at least 2 original copies, one for the court, one for the defendant. If there are more defendants in the case, then you will file more original copies with the plaint. If you don't fulfill all these requirements, your plaint will be rejected. If you see Order 7 Rule 11, not filing the copies of the plaint is also a ground for rejection of plaint. Once you have a plaint which is complete in all respects, it has original copies, it has documents attached, everything is done, then you will go to your filing counter, Suvidha Kendra, facilitation center, whatever it's called. You'll hand them your plaint. Once you give your plaint to them, then in exchange for that plaint, they'll give you a case number record. They will create a case number record and they'll give you that CNR number. It's called the CNR number. Mind you, CNR number is not your suit number. CNR number is a number which is given to you by the filing counter. Once you have that CNR number is generated how? There's a database which is called CIS, Case Information System. Your plaint will be logged into that database. Once it is logged, a number, CNR number, will be generated for your plaint by that database. And that number will be given to you. Why is that number given to you? Because after that number has been given to you, you will use that number to track your plaint. Because after that, once the plaint is in the system, on the notice board outside the filing counter, your plaint number, your CNR number will be mentioned. It will be written as to which court is this plaint going to, that is which court will try this suit. So you will use that CNR number to find out on that notice board where your case is going to be tried, and a date will also be fixed on that notice board. That CNR number, will be tried in this court on this date. That is why you need that CNR number. Then on that date, now who does this? Who tells you, who decides which case is going to be tried by which court? Because in a civil court, if you go and see, there are so many civil courts. There's not just one civil court trying everybody's civil cases. No, there are many civil judges who try the cases. Usually, in every district, so at the civil court level, you will have your marking of the cases which is done. So marking of a case is basically deciding which court will try which case. Your civil judge senior division usually does that marking, and he will decide as to which judge is going to try, which civil judge is going to try which plaint. That is done, and then after doing of the marking of the case, your CNR number is put on that notice board. It is written which court is going to try your case and on which date. Accordingly, you appear in that court on that date. Once you appear in that court on that date, your plaint has already come to the court. The court's reader will go through your plaint. If there are any deficiencies, for example, something in your plaint is illegible, it can't be read, or it has been insufficiently stamped, any deficiency is there, then that deficiency will be flagged by the reader, and this flagging of deficiency will be called office objections. So office objections will be raised on your plaint, and you will be given time of usually 7 days to correct those office objections. And after correcting those office objections, you will file the plaint once again. For example, you did not pay the complete court fees. You will be asked to pay that court fees. It's one of the office objections that can be raised. You haven't filed enough copies of the plaint. The office objection will be raised that enough copies are not filed and some copies are required. You will file the required copies of the plaint. All these can be raised, and whenever an office objection is raised, the office will raise it. Then the presiding officer of the court, who will be the presiding officer of the court? The civil judge of that court will sign that office objection that yes, this objection has been raised. You are being given these many days to deal with this objection and correct it. After rectifying it, then we will begin with the further process.